The next section is an extremely important section also relating to the new amendments or the new companies law and how that will impact you. So it was only introduced just recently, and we thought it would be a good idea to bring that to your attention now at this session, because it is going to get implemented, I think, in about I think the implementation is 150 days from the date of publication in the official gazette, which takes it into perhaps, I think, May 2nd or something like that. So it is very important, and quite important, that we have this 40 to 50 minute session where we highlight the key changes. What I would like to do is introduce to you two esteemed presenters from the law firm of Dentons. First one is Mr. Anas Akil. He is a partner at Dentons and Jeddah practice. He advises companies and foreign investors in setting up and operating in Saudi Arabia, and has handled a wide array of corporate, commercial, and cross-border transactions and disputes in the United States, Latin America, Asia, and the Middle East. His background includes representation of regulatory compliance, insurance, banking, and capital markets. Prior to joining the firm, Anas was the General Counsel and Corporate Secretary of Al-Ahli Takaful Company, a public listed insurance company in KSA. Sorry, I just lost this. Sorry, my apologies, Anas. Oops, technology for you, and I've lost it. It was working perfectly before. Okay. I have it here now. No, I don't. This doesn't have. Okay, so you okay. And then obviously now I'm going to introduce John Balouzier. He's a Dentons and an associate whose practice focuses on commercial law and compliance with Saudi business and labor law. At Dentons, John has worked on high-stake litigation, internal corruption investigations, and government tenders and procurements. Gentlemen.
So I think what Namran was trying to say is that Anas is a highly experienced corporate lawyer in Saudi Arabia. He's a partner in our Jeddah office in Saudi Arabia here, and he previously was the corporate secretary and general counsel of Al-Ahli Takaful, which is a publicly listed Saudi Arabian insurance company, one of the largest. And so he'll be bringing his knowledge and expertise of joint stock companies, closed and public, to the discussion. So we're going to start off. Technology has its benefits and its faults. So again, Anas Akil from our Jeddah office and myself from our Riyadh office. Some of you probably have worked with Dentons. It is now the largest law firm in the world with recent mergers that have occurred throughout this year. We now have over 7,000 lawyers in 150 locations across 80 countries. Throughout the Middle East, we're in the GCC. We are in Egypt. We have associate offices throughout North Africa, or in Amman, in Lebanon. I was previously, prior to coming to Saudi Arabia, based in Abu Dhabi, and prior to that I resided in Syria and Turkey. So we're going to start the discussion off with the menu of business organizations that have been historically available to investors, that continue to be available to investors. We're going to speak about the regulations as they've applied over the last 5 decades since the 1965 Companies Regulations was issued, and how they've been changed just last Friday. This is a very fresh perspective on the changes. We're yet to see how they're going to be applied in practice. We see what the black letter of the law is, but Ministry of Commerce practice often deviates from that, or sometimes doesn't enforce what the black letter is. So we're going to start off with this menu of business organizations. Some of these are not, strictly speaking, business organizations. They're not companies as defined by the Companies Act. They are not even regulated by the Companies Act. Yet we're going to discuss them nonetheless because they're important business forms, regardless of whether they fall under the definition of company strictly interpreted. Many investors choose to use these forms, or Saudi individuals, and thus they're still relevant, and we still must discuss them to get the full context. The first is what we call in Arabic the mu'assisa al-fardiyya. Al-mu'assisa al-fardiyya, literally translated as an establishment, an individual establishment, or a sole establishment. In the West, we're used to calling these individual proprietorships. So in the English, we can, to really truly understand what it is, we should call it an individual proprietorship, because it's nothing more than an individual engaging in some kind of business activity. It's not a company, because company, if we look at the word both in English, as well as we look at the word as it's defined in the Companies Act, is an entity in which at least two persons engage in a business venture where they share any profits and they divide any loss. So there's that element of two. I mean, it comes from the Latin and English, com, which is the basis for common, and panis, which is the basis for bread. Common or shared bread. So a sole establishment isn't a company in the proper sense because it's one individual owner. He takes all responsibility for the debts and obligations. He takes all profits, regardless of whether he's working with others. He might hire 10 managers. He might hire 100. He may have 1,000 employees. Nonetheless, it's not truly a company, and therefore it's not referenced in the Companies Act as such. It is an entity where the owner takes responsibility for all the debts of the company. So there's no corporate veil. There's no separation between the owner as a natural person and the business as a juridical person. Again, this entity is not mentioned in the Companies Act, yet it's still an entity that can be registered with the Ministry of Commerce. It's a very simple process, and I mean, it's so straightforward and basic that when you go to deregister the entity, the Ministry of Commerce doesn't even require you to novate contracts from the entity to the individual because they're seen as one and the same. And in that way, we can, that's a good segue into the next entity, which is the branch of a foreign company. This is an entity that, again, is not governed in the Companies Act of 1965 or the 2016 Companies Act, which, again, as mentioned by Natman, will come out in just 143 days from today. It is referenced very briefly in the 2016 Act. It's nowhere referenced in the 1965 Act. Nonetheless, Saudi recognizes it. Saudi permits it to be licensed. Saudi issues licenses for this entity. What is a branch of a foreign entity? It's basically a sole establishment, but instead of being owned by an individual, a natural person, it's owned by a foreign company or a foreign corporation or foreign partnership. I mean, whatever the business form takes in its country of origin, its local branch, its local presence in Saudi Arabia is what we call the branch of the foreign entity. Because it's not a company in the strict sense, it doesn't have a corporate veil. So it's unlike a corporation or a joint stock company or an LLC or a limited partnership, although a limited partnership doesn't have a corporate veil either, although it does have some limitations of liability, which we'll get to. It's basically, I mean, how does Saudi Arabian law look at this? How does the lens of Saudi Arabia interpret a branch of a foreign company? In the same way that it views the foreign entity. So just as a foreign entity might be engaged in some business in Saudi Arabia, undertaking business activities, becoming subject to debts and obligations, in that same way, the branch is being subject to those debts and obligations. So anything owed by that entity is seen as being owed by the foreign shareholder. Again, it's not a company because it has only one shareholder. And then we get to, finally, the general partnership, which is the first entity that is governed by the Companies Act, and is the first entity that is, strictly speaking, a company, because it involves at least two partners. What is a general partnership? A general partnership is any entity, it's the most basic of business forms. Any entity where at least two people come together with a common interest in engaging business activity, dividing up losses, and sharing profits. There's no limitation of liability. There's no limited partners. Therefore, if you, as a shareholder of a general partnership, engage in any act, whether it's negligent, whether you exercise business judgment, and you thereby cause the company to lose all of its capital, to hemorrhage financially, and you yourself are unable to pay those debts, and the general partnership doesn't have the assets to pay those debts, then they can go after your corporate partner, who's also a general partner, who then becomes jointly and severally liable for all the debts of the company, although he had nothing to do with the decision you made, although he engaged in no wrongdoing, although he didn't even exercise business judgment, he becomes fully liable for all those debts. So his assets are viewed as the same as the assets of the entity. That's the general partnership. The next is, as we get increasingly more sophisticated, is the limited partnership. We finally now introduce the idea of limiting the liability of the shareholders and dividing between the entity as a legal person and the shareholder as a natural person. The two are separate. The two are separate in the sense that if two individuals, independent of each other, one of them enters into a contract and breaches and then becomes liable for a judgment entered against him, in the event that he's unable to pay it, the other individual who had nothing to do with that corporate transaction could have no liability for that contract. In the same way, the limited partner can have no obligation for the debts of the company that he has become a partner of, regardless of, even if he undertook decisions leading to the losses of that company. The most that individual can lose is whatever he invested into the company. We say his liability is limited. What is the difference in principle between them? In essence, it's the general partner who manages and controls. It's the limited partner who, although he may also be engaged in decision making, he is not actually in control of the entity. He's viewed as somebody who's invested in the entity, and thereby his liability is limited to that investment. Then the next entity is these next two, Sharikat al-Muhaseh and Sharikat al-Tawsiyah bil-Asum. These two are just very rarely used in Saudi Arabia. There's no real need for them anymore because, essentially, most investors are going to go with the two forms that my colleague Anas will speak about momentarily, which is the joint stock corporation and the limited liability corporation, because why would you even enter into any limited partnership when you can essentially enjoy, when all of these shareholders can enjoy the limited liability that are offered by the other entities. So with that, I'll turn it over to Anas.
So John described was the other forms of corporations that you generally don't see. What I'm going to be discussing is the corporations that you normally see. So the first one is the Sharikat al-Musahama, which is a joint stock corporation. So what's the advantages of having a Sharikat al-Musahama versus a limited liability company? For one, it's the form of corporation that will take you into the IPO process. So if you're thinking down the line that you want to go into an IPO, then you'll actually set up a joint stock corporation. You don't have to necessarily do that from the get-go. You could set up a limited liability and then move into the joint stock corporation and have it for the minimum required number of years and move on to the IPO process. But it makes it much easier if you set it up as a joint stock corporation. Second is it gives you a lot of flexibility versus the limited liability company. So with respect to the joint stock corporation, it gives more control over management of the corporation than it does in a limited liability company. For one, you can pass shareholders' resolutions just by having a general assembly. So the meeting of the shareholders, the majority of the shareholders, whoever is in attendance of the General Assembly can vote on those decisions, and the majority vote usually is what passes the resolutions. In a limited liability corporation, a limited liability company, it's quite different. So you have to have unanimous decisions by the partners to either amend the Articles of Association or to take any decisions. So everyone here has a sibling, and you can imagine not you and your siblings don't always get along. And if you're in this type of corporation with a sibling that you don't get along, it can get pretty sticky. And in those situations, you end up hiring a law firm, and the law firm steps in and takes all your money. So it's one of those things where if you had a joint stock corporation, you'd be able to actually maneuver your way out of this quite easily by just having the majority of the shareholders attend and vote on decisions. So not all the partners can block it. So there's less rights for minority shareholders in, say, the joint stock corporation. Now, when it becomes public, of course, the CMA rules step in, and per the CMA rules, there's also minority shareholder rights. And now with the cumulative voting and other processes, it's trying to protect the minority shareholder more in these types of corporations. So you need at least 2 shareholders for the joint stock corporation. As I discussed with the limited liability corporation, that's probably the most common form of corporation that you'll see. Any of your joint ventures, whether it's 2 parties in the kingdom or a party from abroad investing in the kingdom with a local Saudi, or even a company from abroad investing in Saudi Arabia setting up an LLC, they'll require two separate entities to come together to form the LLC. With the new law, it only requires at least 1 shareholder. So now any company coming from abroad, like if I give an example of Microsoft, so traditionally Microsoft to operate in the kingdom would require Microsoft, for example, India, and Microsoft Corporation in the United States, they'd come together, they'd form a limited liability company. Now you can actually have Microsoft India come by itself and form that limited liability company. That's with the changes in the new law. So,
what's the difference between the LLC and the limited partnership?
So the limited partnership, let me go back to this one real quick. So with the limited partnership, you have let's say a general partner. And that general partner, his liability is open. It's not capped. With the limited liability company, you have actually both parties, their liability is capped to their share capital. So if your share capital is 500,000 and you have 2 parties, you're only liable up to 250,000 riyals. So let's say you have a judgment against you for 3 million riyals. The party that has the judgment against you can only recover the 250,000. So it's your percentage. With the limited partnership, 1 partner is going to be a general partner in there, and he's going to be liable for the entire debts of the limited liability.
But our lawyer was telling me that Saudi Arabia LLC, even if the company is bankrupt and the assets were not able to offset the liabilities, they still can't go after the shareholders.
You can always go after the shareholders. So you can always sue a shareholder. Like, for example, I can pick a random person from the crowd, and I can go file a lawsuit against him. The question is, do I have a valid claim? So, for example, what's your name? Muhammad. Okay, so Muhammad, for example, I can go to Diwan al-Madalib now and file a claim against you. And you'll have to hire a lawyer, and it'll take maybe 6 to 8 weeks before you can say, I have nothing to do with him, I don't even know him. So it's similar with a corporation. They can come after you for the debts of the corporation, even in a limited liability company. But what happens is, as long as you follow the corporate governance, your liability is limited. So as long as you're not commingling funds, what we see in the Middle East a lot of times is someone has a limited liability corporation, but they run the corporation as if it's their own corporation. So they're dipping their hands into the bank account. Tomorrow I want a Ferrari. I go into the bank account and I say, I'm going to buy a Ferrari from the bank account of the company. So later on, when you end up having liabilities, the court looks back and says, where was the spending? And when they see I was spending on myself personally as a shareholder, rather than for the company, then they tend to say this was a sham, and they can go after me personally. What we call that is piercing the corporate veil. So you're wearing the niqab, and what's happening is basically the liability goes through the niqab to the person behind it. And that's what in law they call piercing the corporate veil.
Thank you.
My pleasure. So moving on, I'll talk a little bit about the Companies Act. We've been, since 1965, using the same Companies Act. I think everyone here in the room probably has seen it. The Companies Act is lots of horrible translations of it in English. I have never seen a very good copy of the Companies Act. And so we're actually quite happy with the new changes and finally getting a decent version of the Companies Act, proper translations of it, even proper form of it. So recently, the Shura Council announced that they're going to be adopting the new companies law. And this is very recent, as of say 1 month ago from today. The Saudi Arabian authorities, or MOCI, came out and said, we're announcing the new companies regulation that's been issued. 1 day later, the royal decree came adopting that, the new companies law. And last week on December 4th, they published it in al-Qura, which is the official gazette for Saudi Arabia. So at 150 days after publication, which is May 2nd, it will kick in, and it'll be effective. And so these new laws will actually kick in. So there are some substantive amendments to the new law that we want to discuss. I'll discuss them briefly here, and John will get into more details about those. But for one, the number of shareholders of the LLC has been reduced. And as I said, it went from being a minimum of 2 shareholders to 1 shareholder, which now allows any of us in the room to basically set up an entity by ourselves with limited liability. So it gives a lot more flexibility to an investor and foreign investors to coming in. So a lot of our clients, in the Microsoft example, a lot of our clients who want to come into Saudi Arabia, sometimes they're actually compelled to start a new entity, a subsidiary, just in order to invest here, because they may not have an extra shareholder to come in. So with the 2 shareholder requirement, they have to form a new entity. Now they can just form one entity using the main parent entity or any subsidiary. The number of shareholders for the joint stock companies have also been reduced, which will allow people to establish a joint stock company easier. The minimum share capital, again, of the joint stock companies has been reduced. And again, John will discuss these in more detail, so I'm not going into specifics here. The minimum statutory reserve for the LLCs and the JSCs has been reduced also from 50% to 30%. And what that is normally with these statutory reserves is you have to take a percentage out of your profits and set it aside into a reserve until it meets a percentage of your paid-up capital. And those have been reduced again, which means quicker profits for, say, a corporation. The regulations relating to the capital loss of the LLCs have also been amended, and the regulations relating to the capital loss of the JSCs have also been amended. Now, some of the other amendments that are there are online publication of the Articles of Association and amendments. Now, what that means to you, and as well as us in the legal industry, what that means to you is your legal bills actually should be less because we don't have to go down to the Ministry of Commerce and Industry. We can actually file things online, which is very helpful when you get technology mixed with different professions. So instead of me going down to the Ministry of Commerce and spending 2 hours, I can actually just upload it, wait for their response, similar to what Sajid has been doing with the foreign investment applications. So that's helpful for both of us, actually. It gives me more time in the office to focus on things that we need to get done rather than spending time in traffic and going down to the ministries. And it also lessens the burden on the ministries. The other thing is the reduced par value. So the par value of the JSCs has been reduced from 50 to 10 riyals. It's just basically more shares will have to be issued, but it allows an opportunity for more shareholders to come in as well, and then a lesser requirement for those shareholders. The board of directors, so historically, the old 1965 companies regulation required with the board of directors, it said it's a minimum of 3, but it never capped the maximum number. Now it's capped at 11, so it's a minimum of 3, and up to 11 members can be on the board. Just in terms of a practical tip, 11-member boards are usually disastrous. It just takes a long time to get anything done. So the typical what you would want to see is boards around 5 to 7 members are usually perfect. And anything above that, you start seeing that it becomes a lot of bureaucracy on the boards. Ownership of directors' shares. So the 1965 law required that each director on the board owned 10,000 riyals worth of shares in the company. And a lot of the public companies had these issues where they said, okay, our shares are being traded on the stock market, it goes up and down, it fluctuates, how do we calculate the 10,000 shares? Should the directors go out and buy these shares in the market? From standard market practice, what they were doing with these qualification shares is usually the major shareholders in a company were blocking 1,000 shares, par value of 10. They were locking it in the Deloitte account and issuing it to those directors. And when you step down off of the board, they were basically taking back those shares back to the portfolio of the listed company, and they would go to the next director who was appointed. So now they've done away with that. So there's no longer a requirement to have these 10,000 riyals worth of shares. The other thing that's important, of course, is the remuneration of directors. And we always get a lot of questions on the remuneration of directors from listed companies and even limited liability companies. A lot of the directors say, we're doing a lot of work, we're not getting paid for it as much as we should be. Like some boards of directors are moving smoothly, others it takes a lot more. Either there's conflicts in the company, compliance or corporate governance that needs to be implemented. So a lot of times people say, we're not getting paid as much as we should be if we were on another board. So the cap was 200,000 riyals from the 1965 regulations, and now that has been increased to 500,000 riyals for a board member. The other thing that you should pay attention to here is it says if remuneration of a director is based on a percentage of the company's profits, it may not exceed 10% of the net profits after deduction of the reserves that I discussed and the payment of dividends. So some view that to say if you're not paying any dividends, you cannot pay the board of directors. The issue with that is if you apply a rule like that, then you won't have anybody trying to join your board. And that's for listed companies where you require independency of 1/3. It's very difficult to get someone if you're saying we're in losses and we're not going to be paying anybody. So that's one of the things that to keep in mind. With that, I think I'll pass it over to John to continue to get into more specifics on the rest of the amendments.
Okay, so we're going to talk now about, we'll start with the ownership regulations. So ownership is the first thing that was changed for both LLCs and joint stock companies. Just as an overview, some of these laws, I think you can see them as sort of coming towards the Western model that allows for a great deal of flexibility in ownership and management. So historically in Saudi Arabia, the Companies Act has restricted ownership of both joint stock companies and LLCs to 5 shareholders for the joint stock company and at least 2 shareholders for LLCs. And now with this new change, allowing for as few as 1 shareholder for both LLCs and joint stock companies, we see this rapprochement with the Western model. And just as a little bit of context to that, all of these entities, I mean, other than the most basic of the general partnership, all of these entities are entities that are created by statute based on the Western corporate model. When you open up any text on Islamic law, on Islamic jurisprudence, a business law book on Islamic law, you read about business organizations like the Musharaka, or you might see arrangements for financings like the Mudaraba or Murabaha arrangements for financings, or Mudarabas as partnerships between Rabb al-Mal and the actual, Rabb al-Mal, the sleeping partner, and the Mudarib, an actual acting partner. But you won't read anything about Sharikat Zat al-Masuliyya al-Mahduda. This is a model that came in from the common law, and the Companies Act, in trying to bring in foreign investment, has been making it easier and easier, reducing the shareholders, reducing the amount of capital for foreign investors to come in. Just given the size of the Saudi economy, given the amount of cash and of oil reserves, we're talking about 1/4 of the world's proven oil reserves, the government has money it wants to spend, it wants to bring in the Western expertise to build the Saudi infrastructure, to bring in the West to become a partner for the future of this country. And the way it's doing it is through this new law, which in just 60 pages outlines all of the regulations for everything from the most basic general partnership to the most sophisticated of publicly listed, multi-billion riyal paid-up capital joint stock companies in 60 short pages. I mean, if you just imagine how simple that is, when you consider, for example, the limited liabilities code for the state of New Jersey, for the single entity of limited liability codes exceeds that substantively. So the first change was with LLCs, historically 2 shareholders. That's been reduced to 1 shareholder. Now there are some limitations to this that are worth highlighting. The first is that we're assuming that we're not in one of the areas that has been historically restricted to Saudi Arabian or GCC entities. So, for example, anything that you see on the negatives list, which doesn't permit foreign investment, or an area where the SAJE still requires at least a Saudi shareholding in the entity, such as, for example, trade and distribution. Regardless of whether you're an LLC, you cannot bring in a sole foreign shareholder because you need a Saudi 25% shareholder. I mean, that restriction continues to apply, despite the fact that it's being discussed, despite the fact that there's even current discussions about removing that restriction. There are still these residual restrictions following the 2005 entry of Saudi Arabia to the World Trade Organization. Another restriction is in cases where you have a single-owned LLC. A sole shareholder of a single-owned LLC cannot then go and form another sole shareholder LLC. He can only be the shareholder of a single shareholder LLC. If he forms a second one, he needs to bring in a second shareholder. Similarly, an LLC that is owned by a single shareholder cannot then form a subsidiary sole shareholder LLC. To form a subsidiary, it needs to bring in at least a second shareholder. But in most cases, in 95% of the cases, a single shareholder LLC will be permitted, which I believe means more foreign companies are now going to be opting for LLCs, whereas in the past, where they wanted to have full control, where they didn't want to have to deal with a partnership, they went with a branch office model. Joint stock companies historically needed to be owned by 5 shareholders. That has been reduced to 2 shareholders, so the current general rule is 2 shareholders with 2 exceptions. The first exception, if you have paid up capital of at least 5 million riyals, you no longer need that second shareholder. The second exception, if you're the Saudi government, regardless of what your paid up capital is, assuming that you meet the minimum paid up capital, which is the next change we'll get to, you can form a sole shareholder joint stock company. Now, what does Saudi government mean? I mean, it's broadly construed to mean not just the Saudi government itself, but also publicly owned companies. The most prominent example, I think, which is probably on all of your minds, is Saudi Aramco. I mean, Saudi Aramco is owned by the Saudi government, therefore it can form its own sole shareholder joint stock companies. The next change has been with respect to the paid-up capital. Paid-up capital has historically been 500,000 riyals for LLCs and 2 million riyals for joint stock companies. Now, that has not changed for LLCs, and by the way, that's the general rule. In some cases, you need to pay far more than that, but we'll just stick to the basics for now. For joint stock companies, it has been reduced. It is now 500,000 riyals, and sufficient to achieve the purposes of the company. In our talk at Khobar 2 days ago, the question came up regarding a publication the Ministry of Commerce has put out regarding changes to the companies regulations under the 2016 law. And the publication lists all the entities governed by the new law and all the elements and all the characteristics, and it shows paid-up capital, joint stock companies, no change. That's actually an error. The law does state, I believe it's Article 54, that the paid-up capital has been reduced. Press releases have announced that it's been reduced. So our understanding is that that publication, which some of you may have seen, is an error. Next, we'll be talking about requirements in the event of capital loss. This is, I'm sorry, we skipped one. The statutory reserve of LLCs. Statutory reserve of LLCs has historically been 10% of annual profits per year set aside until the statutory reserve reaches 50%. That's the minimum under the 1965 regulations. By the way, when I reference 1965 regulations, I mean as amended by all of the resolutions and circulars that have come out in the last 5 decades. So it's been until you reach 50%, that's the minimum. Some companies, not many, but some do opt to raise that statutory reserve to higher than 50%. Now, in the event you hit that 50%, following the year in which you hit 50%, any profits you make, you have the discretion to choose what to do with. Declare a dividend, reinvest, and so on and so forth. The current rule is that you must set aside 10% until you reach the 30% threshold. So it's gone down from 50% to 30%, which is another encouragement and is another way that demonstrates the Ministry of Commerce looking to give business investors and Saudi business persons more flexibility with their money. It's no longer being tied up in paid-up capital. It's no longer being tied up in statutory reserves. The money can be invested as they wish. So from 50% to 30%, so you now have an extra cushion of funds to play with, to distribute, to reinvest. Requirements in the event of capital loss. I consider this probably to be one of the most important changes, if not the most important change, because of its implications to the risky nature of doing business in Saudi Arabia. Historically, you had a certain degree of uncertainty in the legal market because once you invest in, say, forming a joint stock company with, let's give an example, 2 million riyal paid up capital, historically under the 1965 regulations, as they've been amended twice, in the 60s and in the 90s, a company can only lose up to half of its paid-up capital, historically 75%, but then it's been reduced to 50% for LLCs, remains 75% for LLCs. At the point where it hits that threshold of 50% for LLCs or 75% for joint stock companies, the shareholders can become personally liable, subject to joint and several unlimited liability for all debts and obligations of the company if they fail to act, if they fail to come together in either an extraordinary general assembly of the joint stock company or a meeting of the shareholders issuing a resolution of the LLC and decide to either act to raise the capital or willingly accept the debts of the company or dissolve the company. So historically the rule has been they become liable. The entire essence of the business organization as such is to create an entity, a person, a legal person that contracts its own debts and obligations to protect the shareholder. I mean, this is what the corporate veil does. That entire corporate veil dissipates, is pierced in the event that they fail to follow that procedural requirement. And that's a pretty significant thing. I mean, we see in Saudi Arabia all the time that Saudi Arabia is a very important economy. It's certainly the largest economy in the Middle East. It's one of the largest players in the world with 1/4 of proven oil reserves. And there's a lot of money to be made in Saudi Arabia. There's also a lot of money to be lost in Saudi Arabia. Companies want to see their investments protected. And so they're very concerned about this. And I've been practicing in Saudi Arabia for 5 years and seen countless times companies come together recognizing all too late that they failed to call together the shareholders meeting within 30 days of the date where the capital exceeded 50%. And the question is, what do we do? Well, you've become personally liable for all the debts. You are no longer a limited liability company. Your protection has been pierced. And today, that has all been changed. And when I first read about this, I thought it was great news. It certainly sounds like great news. When you read the press releases, it's that shareholders whose losses exceed 50% of the company's paid-up capital. 50%, we're talking about LLCs, we're going to talk about joint stock companies in a moment, but it's the same for both. If it exceeds 50% of the paid-up capital, the company will not be the shareholders will not be held automatically, personally liable for the debts of the LLC. No longer will they be held personally liable for the debts of the LLC. That sounds really great in principle, right? It does. But then I kept reading, and then I realized this actually isn't really good news because historically, you had 3 choices. You could become personally liable for the debts of the company. You just willingly call together your shareholders and say, we want to continue this company. We recognize the uncertainty of our future, but we recognize that we also want to keep going forward. We have a business plan. Next year we're going to build profits, or we have a 5-year plan. We want to keep going forward. That was your choice. But you also had a choice to dissolve the company, or you had a choice to raise the capital and exit yourself from an Article 180 for LLCs, capital loss situation, or Article 148 for joint stock companies, capital loss situation. So raise the capital, continue the company, or dissolve. Well, today you no longer have that choice. Once you hit that threshold of 50%, if you fail to call together your shareholders and take action, you're automatically dissolved by operation of law. Yes?
What about government companies who has no activities? More than 1 year. What did the law say about it? It
Well-
doesn't create business, it doesn't maintain profits, just done.
Well, I mean, the law doesn't specifically speak about dormant companies, but what would apply for an active company would apply to a dormant company. Now, if a dormant company at the time that it went dormant was in a situation where its income had exceeded its losses and its, or it had losses.
Now, what I mean, is something in the law say this company shouldn't exist anymore, should be dissolved, or what else?
Well, I'll just tie it back to this specific, let me tie it back to this specific share loss example. If it's been dormant, and its paid up capital is still there, therefore in the last 5 years, say, it hasn't had losses that go beyond that, then it wouldn't enter into this situation. Now, if it's been dormant for the last 5 years, but the last time that it did business was 6 years ago, and at that time, it had been in a situation where its losses were above 50%, then this is a company that would be in breach of the 1965 regulations, and therefore its shareholders would be liable, regardless of whether it has been doing business for the last 5 years. So going back, today, you're automatically dissolved by operation of law. So you no longer have that choice. You no longer have that choice. Now, the law doesn't actually say what does it mean that you're dissolved by operation of law. I mean, is there somebody sitting in the Ministry of Commerce who's reviewing every quarterly report, every annual statement that comes in, and trying to see, well, what was their paid up capital, and let's look at their losses, and does it exceed? And oh, this one does, check, cancel their CR. And tomorrow you can't renew your license, your Saudization certificates, your labor and zakat certificates, and you can't bring in employees, and you can't bring in, you can't get business visit visas, and you can't renew your iqamas. We don't know. We don't know what it means. I personally don't think that's going to happen. I think probably what's going to happen is the same thing that's been happening for the last 50 years, which is that any interested party, any creditor, any lender, any investor who's really concerned about his investment realizes that this company is losing his money and is hemorrhaging, and therefore, as an interested party, can go to the Ministry of Commerce and complain. And the Ministry of Commerce, in responding to that complaint, can then refuse to renew the CR certificate. That's my take. What do you do when you fall into this situation? What do you do when you hit that 50%? It's a little bit different for LLCs and joint stock companies, but the principle is the same. You need to call together your shareholders, and you need to decide what to do. You need to decide what to do. Now, the first option, of course, is what you've always been able to do, which is we dissolve the company. We have no business plan, we have no future, so we're just going to dissolve now, cut our losses. The second option is, now this is where it's a little bit confusing, because the revised article for the LLCs, which is Article 181, says the shareholders can decide to continue the company or dissolve it. And it doesn't really make sense what it means to continue the company. What is the point of the article? What is the point of even talking about this threshold if you can just continue the company? I mean, why even call together the shareholders if your option is to continue the company? Obviously, we can continue the company regardless of whether we call together the shareholders once we hit 100% capital loss. So I think what actually they're trying to say, but it's not in the text, is what they say explicitly for LLC, for joint stock companies, which is they have the option to come together to decide to continue the company by increasing the share capital such that whatever losses you had are now no longer more than 50%. But they just don't say that. So with joint stock companies, the rule, and it actually says for joint stock companies, and another form of language and expression that I don't think is really clear is that they can come together and they can decide in their resolution to either dissolve the company or increase or decrease the share capital in order to address the capital loss situation. I believe what they mean is increase the capital. Decreasing the capital is not going to help you. It's not going to help your lenders, your creditors. It's increasing the capital that's going to get you, and that's going to be your exit strategy from the Article 150 for joint stock companies regulation. For LLCs, another change that has been made is that you traditionally had 30 days to call together your shareholders and decide whether or not to continue the company or dissolve. That has been increased to 90 days. Why? I think historically it's just been so prevalent that within 30 days of losing your capital, it's not really practical to call together your shareholders. Oftentimes you don't even realize that you lost more than 50% until your quarterly report comes out or your annual report comes out. And when it does come out, you need a few weeks to get your board members together or your shareholders together, or to even issue a resolution in the form that the ministry requires. Takes you through a notarization and authentication process through the Saudi Arabian embassy in the country where the shareholders are based when it's not a Saudi-based company. It takes weeks, sometimes months, to get all this to come through. All too often, 30 days just isn't enough time. So they've increased it to 90 days in light of the impracticability of the former requirements. For joint stock companies, it's also been changed. Joint stock companies, it's 15 days, 15 days from when the capital loss exceeds 50%, for the auditor or the chairman of the board to call together the other directors and inform them of the capital loss. The board of directors then has 45 days to call together the shareholders into an EGA, which then must decide whether to dissolve the company or increase or decrease the capital, which I believe means to increase the capital. Once they decide to increase the capital, they have 90 days to implement it. It's 90 days. After that 90 days, if you fail to increase the capital, again, you no longer have that choice of just continuing the company with the shareholders becoming solely liable, personally liable. Now, under the new law, you fail to increase the capital after 90 days, the company is dissolved by operation of law. Very important change. I'm sorry? Yes. It's from what? Yes, please.
Cut-off for the new law of the is 2nd May 2016.
That's correct.
So what happens to those companies which have already crossed to the 50% threshold? Suppose some company crossed threshold in April 16, for example. So what happens to those companies which have crossed threshold before the application of the new law?
Okay.
From which date this time will be counted?
Yeah, well, one of two things happens. Either that company calls together its shareholders into a meeting and they decide to resolve to continue the company or dissolve the company or raise the capital, or they don't. If they don't, then the company can continue with the possibility that a third party who's interested can request the dissolution of the company, which is not automatic. Or if that doesn't happen, the company just continues to do business, but the shareholders become personally liable for the debts of the entity.
My question is that this 90 days, because previously it was 30 days, now it's 90 days.
Right.
So this 90 days change will apply for which date? Because if any company is 50% cross after this application of new law, no problem.
Yeah.
But if some company crosses before this application of new law, so from which date it will apply?
Yeah, so from 2nd May 2016, it's the 90 days that begins to apply. Yeah, I guess you have an interesting question, because what happens if it's, let's say that it's 30 days just before May 2nd. So let's say we're at 3 April 2016. The company hits 50%. Do you apply 30 days to call together the shareholders? Or, because on 2 May 2016, the new regulation is in place, do they now get that extra 60 days? The question is, we just don't know these. These are the kinds of questions that in the months and the years to come, we're going to see how the Ministry of Commerce actually applies this in practice. There's another question.
Yeah. Now, what if we acquire a company that's already in the starting with 50%, 30 days have passed, they haven't met or made any decision on what's going to
Could you
do?
just start with
Okay, what if we want to acquire a company that's currently the losses exceeding 50% of their paid capital, and 30 days has passed and they haven't made any decision? So if we acquire this company, what would be the position of the Minister of Commerce? Will they accept that, or?
If you acquire the company?
Yeah.
You're talking about what would be the position of the Ministry of Commerce on the new acquirer, of the acquirer?
Would they accept this as an existing company, or would they consider it as a dissolved company?
No, well, by default, it still exists as a company. It hasn't been dissolved unless an interested party requests its dissolution and the Ministry of Commerce grants that dissolution. So the company continues to exist. Now, the real question is, why would a foreign shareholder that does its due diligence ever invest in a company that doesn't have limited liability? That new shareholder would inherit all the debts and obligations of the local entity. Is that clear? Thank you. Okay, and with that,
John,
yes,
please here. We keep saying 50 days, 90 days. 90 days of process of reaching the process over here in the back. Here.
oh yes,
Okay, so 90 days of process. Actually, in real life, we don't recognize that until it's the end of the year. So by the end of the year, we can see the financial statements, so we can manage that it is 50% or more. But in real life, it may happen during the first month of the year, first 2 or 3 months of the year, we reach more than 50%. So it's not obvious in the law, when should we report that?
well, I mean, it's clear what the law says. The law is very clear in that you need to actually call together that meeting within, currently it's 30 days, and soon it will be 90 days, or in the case of joint stock companies, 45 days, of the date where the company experiences the capital loss. So it's not the date where you receive your annual reports. That's what the law says. Now, how is it applied? I mean, we've seen so many cases where we have foreign shareholders coming to us saying, look, our company experienced losses in September 2014, right? And we are in February 2016, far beyond the 30 days. Or, I mean, just to give you a real example, we have one client who has experienced capital loss in 2013. And in early this year, 2015, we were filing at the Ministry of Commerce the Article 180 resolutions. The Ministry of Commerce doesn't really sanction companies that fail to meet that 30-day threshold. It's not really practicable to meet it anyway. So they just accept the resolutions, you just so that you publish it. And in reality, in the past, it wasn't really much of a difference anyway, because whether you issue the resolution saying that we hereby accept personal liability for all the debts of the entity or not, you're still going to be liable for the debts by operation of law. That was the historic rule. Now it's just that you're dissolved by operation of law. So how is that going to play out in the future? Is the Ministry of Commerce going to hold to a 90-day cutoff date strictly, and then go off canceling CRs of companies that fail to meet it? We don't know.
John?
Yeah. Yes, please.
What do you mean by personal liability?
Personal liability.
If he dissolves the company, the thing is bankruptcy.
Well, if you dissolve the company, yeah.
Legally,
Well,
Bankruptcy, if you announce bankruptcy, there is no liability on that.
right. Well, first of all, assuming you don't declare bankruptcy, and assuming that you don't dissolve the company, then the debts of the obligation of the company are on the shareholders. Now, once you dissolve that company, then that company no longer exists, or once you declare bankruptcy, and you get the bankruptcy order that forgives the debts of the company, or in whatever way divides up its assets among its creditors, then the company fulfills its obligations to those creditors as long as it follows the bankruptcy judgment. So what I'm saying is, before that happens, the shareholders become liable, and that liability is personal, unlimited, and joint and several, in that it doesn't matter which shareholder undertook the action, all of the shareholders are individually responsible for all of the debts of the entire entity, regardless of how little of that entity you own. And that's actually why I think this is perhaps the most important development of the 2016 Companies Act.
Is there any definition for the word deemed delusion in the law?
Is there any definition of?
For the word deemed delusion.
I'm sorry.
Like, when we are saying a deemed dissolved, so whether in the law any consequences has been defined for this, or whether any difference has been given?
Well, I mean, to be very precise with you, what the law says is joint and several liability. Joint and several liability. I throw in individual just to make it clear that each shareholder is individually responsible for all the debts of the entire company, regardless of how little that it owns. That ends my presentation. I just wanted to highlight also, if you find yourself trying to understand Saudi Arabia's business regulations, it can be very challenging because laws often aren't published, and when they're published, it's unclear how they've been amended and which laws are applicable. This legal guide, which my colleague Amjad Hussein and I have published, sort of guides you through the regulations that govern doing business in Saudi Arabia, labor regulations, tax, finance, dispute resolution, arbitration, sort of the birth of the company, through to its demise, right up to its bankruptcy and dissolution. It is a treatise that I believe brings legal certainty to an uncertain marketplace and helps new entrants into the Saudi market find their place here. The Saudi market is far too big, far too significant for it to be limited to the current players. So as somebody who feels like, or at least considers himself to be a friend of Saudi Arabia, I think this book plays a really important part in sort of bridging the divide between the Saudi Arabian market, which is hungry for foreign investment, and foreign investors who are looking for those opportunities. So with that, I'd like to invite, if we have time, Anas to take questions.
I don't think there are any questions.
Or if there are any questions. Yeah, there's one. Is that a hand? Okay, I guess we were very clear. Should we give it another minute? Okay, well, thank you all very much.
I think there is a question.
Oh,
There is a question.
One question, please. We started saying that the foreign branch or RP is not covered under the new complex law, as it is covered only under the SACI. So again, we say that this foreign branch is solely owned by a foreign entity, so it should be covered under the company's new law as a sole company, one solely owned company.
If I could just make a clarification. They gave us 30 minutes to do this talk and 10 minutes for questions. So a lot of what I've said are broad brushstrokes, and I don't go into all the details. So just as a clarification, what I meant by it's not covered under the new business law, I mean, there's part 1, 2, 3, 4, etc. up to part 9, and there's no part that's dedicated to branches of foreign companies. It's referenced in the law. It's there. I mean, it says in the 2016 law that all entities, whether branches or limited liability companies, etc., shall be subject to this rule or X rule or to this regulation. So it's there. I mean, it's recognized in the law, but the law doesn't speak about, for example, how do you form it? When do you publish the articles, or whether you even need articles, which you don't actually, in the way that it does for all the other entities that in the first 2 slides that you saw show what specific part it's governed by. So how do you know how to form it? How do you know how it's governed? How do you know the liability regime? How do you know the tax regime, etc.? Well, that's why you hire us. But more seriously speaking, this is a creature of Sajia. It's not a creature of statute. So, I mean, the way you find out these things is by going to Sajia and getting the list of requirements for forming, understanding, what its regulations are, how it's licensed, how it's treated, what kinds of reports it must file, etc. So you won't find any of that information in the 2016 law. And then in addition to that, because the branch is a relatively new animal, it's not referenced at all in the 1965 law.
But I want to say it also applies to, like, say, non-foreign entities as well. So for example, like GCC entities that are not considered Sajia entities or foreign entities by law. So they're considered almost similar to a Saudi company. So you can also establish a branch of a GCC company as well with the MLCI without having to go to Saudi. Thank you very much.
Thank you.
Thank you, John. Thank you, Anas.